Mr Chairman.
Honourable Phil Goff.
Mr Chairman, I was hoping that the Minister might have taken the opportunity to answer some of the relevant questions put to her by my colleague Charles Chevelle, but perhaps I can add to those questions and seek a response from her on it. As you'll know, the opposition on this bill worked constructively on it. We did not oppose everything. We got some changes that we needed to have. Maybe the Minister can explain to us, for example, why the original bill wanted to have strip searching without the approval of the manager of the prison. That seemed a crazy idea to members on both sides of the committee, and we were able to get some changes. But there were some areas very clearly where no changes were made because there were ideological differences. I should say that privatisation of prisons is an ideological view, and maintaining prisons within the state sector and having decisions made about the liberty of people and the rights of people who have their liberty and rights properly removed by the courts, we don't believe that that should be subject to a profit motive or a commercial organisation. But I wonder whether the Minister actually read some of the submissions that were made to the Select Committee by some fairly authoritative groups. We're not talking about people who came in with nutty submissions. We're talking about very thoughtful people with a lot of experience in the prison system that came in with questions and suggestions. If I look at the delegation of authority to private contractors for security classification or for temporary release from prison, for example, it was argued very strongly by people like the prison officers themselves that it was inappropriate for the Chief Executive to lose control over private contractors by delegating power to them. Both the Corrections Association and the PSA made that point. Just Speak, which is a group that focuses very much on how our prisons have run, considered that delegating the Chief Executive's powers to contractors breaks the chain of accountability through the Chief Executive to the Minister in Parliament. And I think that was a fair point as well. Another group is the Human Rights Foundation, and the Human Rights Foundation receives funding from the government because it performs an important role, and everybody in this chamber respects and wants to safeguard the human rights of all New Zealanders. Some New Zealanders who commit serious crimes lose some of their rights, but they don't lose all of their rights. The Human Rights Foundation considered that delegating the Chief Executive's power to private providers, in particular the powers of temporary release and removal and the powers relating to security classification, increased the risk of human rights violation. They were less convinced that a private provider working under a profit motive would uphold those rights because their motive, of course, they're running a business, they see it only as running a business, and therefore they'll cut corners, and if that comes at the expense of rights that are properly retained by detainees, then they'll do that. Some submitters consider that giving certain powers to private prison contractors would create perverse financial incentives. In particular, you've got financial penalties for escapes. Now, in one sense, that's quite good. It sharpens up their act to try to make sure that they're managing the prison properly, albeit that the private providers, because they're out to make a profit, have cut the staffing inmate ratios. They've reduced the conditions of employment of those that are working there, and they have less concern about the security of the public. If it's going to cost them money to do it, they don't want to do it. So the government decided to counter that natural tendency of bringing the profit motive into prisons. They would penalise private contractors by who allowed escapes, for example, or escapes that occurred in that regime. They'd put financial disincentives in. But because you've got financial penalties for escapes, the submitters put to us, and I think it was a fair point, that private prisons would be less likely to grant temporary release, even where it might be justified, or to assign low security classifications where it might be justified. So you have these important submitters, Mr Chairman.
Honourable Phil.
You have submitters like the Law Society, the Human Rights Foundation, the Corrections Association, Just Speak. You've got the Ombudsman that raised concerns about these sort of issues. And what I want to know is, really, given the experience of Serco as the private contractor that runs Mount Eden Prison, and to whom the Minister has given the contract for the new Wirri Prison, they're going to make $1 billion over the next 25 years. $1 billion they're going to make from the taxpayers' money to run prisons, and that money is going to go out of the country and back to the shareholders in the United Kingdom and elsewhere. Well, that's not a very good idea for a start. But the Minister must have looked at the record of Serco, both in New Zealand and overseas. She must have looked at the fact that out of the 34 conduct standards or performance standards, they failed 19 of those. That must worry the Minister. This is a brand new prison. You know, it's the easiest prison in the country to run because it's built to modern standards by the previous government. I signed that off personally. And it is much easier to manage that prison, yet they have failed. They have released people that weren't meant to be released. They've detained people that were meant to be released. There was at least one escape there, and the track record really is pretty poor. And, you know, you might say, well, it's a settling-in period, it's teething. But if you look at the record of Serco, Minister, in Australia, and running the immigration detention centres, such as Villawood in Sydney, you look at their record in running health institutions in the United Kingdom, a common theme comes through what happens when Serco's put in charge. And that is, they try to cut their costs by cutting staffing, and when they're understaffed, problems occur. There are breaches of human rights. There are things that shouldn't happen. The security of the public is lessened. The service that's provided is not as good as it should be. And I wonder whether the Minister has looked at that record, and if she had looked at that record, why she gave a contract for Wirri Prison, out of which Serco boasted to the London Stock Exchange they'd make $30 million a year. We've seen these submissions to the Select Committee. Responsible, experienced, articulate people saying there are these problems here, you should not be going further down the track, but still the Minister persists in doing that. And I think she owes the House an explanation as to why she has continued down this track when there is no evidence at all that privatisation of prisons is going to improve the quality of the prisons and reduce the cost to the taxpayer. To the contrary, I think it will increase the cost to the taxpayer in the country. That money will go out of the country and the quality of the service will be less. You cannot compare Mount Eden with some of the ancient prisons we've got, yet they did not succeed in meeting their quality performance standards in their first year. And as we've seen overseas, they might get better, but then inevitably there are problems as the profit motive comes in and they cut the corners, and that comes at a cost to public security and the proper incarceration of people in this country. So that was the first of the issues, Mr Chairman, and it's fundamental to this bill. It's set out under Clause 5 of the bill and the delegations of powers and functions of the Chief Executive, and I think the Minister needs to answer those questions. She's had advice from her officials. She should be equipped to answer those questions. But I've got to say, listening carefully to all of the submissions that were given, these submissions were powerful submissions. They made compelling points, and we have not seen any evidence that would justify the ideological viewpoint that somehow privatisation of prisons is best. Is this just another way of cost-cutting? Because that's what it seems to many people in this House across a range of different political parties. Privatisation does not deliver what we want. It doesn't deliver the level of security. It doesn't deliver the quality of services. It doesn't maintain the rights that need to be respected. And it puts the staff of the prisons at risk because it cuts the staffing, it puts the security of the public at risk. And I don't think that's good enough, and I think there should be an explanation on those points. Mr Chairman, I want to come, and I'll only just start to touch on this, clause 26, the definition, Mr Chairman.
Honourable Phil Goff.
The definition of strip searching. And look, I understand that you've got difficult people that you're dealing with in prisons. And I understand that you have to have a way of preventing contraband entering prisons. And I understand that there are times when the most intrusive form of strip searching may be justified. And that's recognised under the current law. It says that if the prison manager has reasonable cause to suspect, then he can employ that most intrusive means. That is the use of illumination, the use of mirrors around the genital and the anal areas. But the current law also makes another point, that whereas somebody is simply coming back from a work party into the prison and there's no cause to suspect, subjecting people to that form of intrusive strip searching just isn't justified. Just isn't justified. And we heard, again, a range of submissions that made that point very clearly. And the first point, of course, was made by the people that work in the prisons. You know, you'd expect them to be pretty hard-headed about their decisions, but the Corrections Association itself acknowledged that this change, to have the most intrusive form of strip searching on every occasion, including routine occasions, was going to have a detrimental effect to relationships within the prison. And they said to us that they didn't support the provision. They were unequivocal about that. They said that it is simply not needed and that this would constitute a serious impingement on the dignity of prisoners and also on the staff having to conduct those searches. Because it's awful for the inmate, but it's equally awful for the staff member that's got to conduct a search of that nature. And they made this point, and Minister, I want you to focus specifically on this point. They said if we've got a real cause to suspect that somebody has concealed a drug or other form of contraband internally, what we do is we put them in a dry cell, and nature inevitably takes its course. And if they are concealing something internally, that object will sooner or later be passed by the prisoner in the dry cell, and the prisoner will have no way of concealing it, no way of hiding it. And what's more, when we went to Remataka Prison, Jackie Dean was there, and it was a cross-party group. It was a very good visit. I asked in front of my colleagues of the manager, if a person has actually got something concealed internally, will this intrusive form of strip searching reveal that object? And his answer, and Jackie and Asanati and the others that were with me will back this up, he said no, we won't be able to tell. So you're bringing in this intrusive form of strip searching, which the managers and the staff say are not the right way to find concealed objects. They pointed out as well that if there's good cause to believe that there is a concealed object, they can use scanning, they can use what's called the boss chair, which I think is in one of the Auckland prisons, the Parry Max. There are other ways of doing it that are more effective. But they made this point as well, and this was a point made by the Law Society particularly strongly. They said, first of all, where is the evidence that we need to increase the intrusiveness of strip searching because there's a growing problem? They said, actually, the opposite is occurring. When I was Shadow Minister of Corrections back in the late 1990s, Mr Chairman, I was appalled. I remember going to the prison actually in Linton, in my colleague's electorate, which I think the security was a 7-wire fence and open windows. But I was appalled that 36% of the inmates, after a long period of national government, were testing positive for drugs. And that's just not good enough. You know, it's easier to get drugs inside the prison than outside. We brought in a range of measures that actually tightened the security in prisons. As Minister of Justice, I supported it. As Minister of Corrections, I did it. We managed to get the level of positive testing for drugs from 36% down to 5% by the time the National Party took office in 2009, 2010. So actually we've dramatically improved the situation of security in prisons so that people aren't able to smuggle objects in. And of course we closed off the cell phone by jamming the cell phone, so there wasn't an order and supply that there used to be back in the 90s under the National Government. These measures are working, Mr Chairman. These measures are working, Mr Chairman.
No, I'm going to have a change. Jackie Dean.